Hi guys, how you doing? This is Ben, the Real Estate Pro, coming at you. Hopefully, going to kick you some knowledge. So I came across this article today from Housing Wire. It's entitled "Utah Realtors Boycotted Homey Listings Over 1.5% Buyer Broker Commission Antitrust Lawsuit." The suit claims it was harmed, it being Homey Technologies, was harmed by anti-competitive practices of NAR, a Utah MLS, and some of the nation's largest real estate brokerage firms. In a lawsuit filed Thursday, real estate startup Homey Technologies claims that home seller consumers were not the only ones harmed by the real estate industry's alleged anti-competitive practices. So the defendants in the lawsuits are the normal, or what was in the other lawsuits as well: the National Association of Realtors, Anywhere Real Estate, Keller Williams Home Services, Remax, and a Utah-based Wasatch Front Regional MLS, which does business as UtahRealEstate.com, is also named as a defendant in the suit. Now, in the complaint, Homey claims that it's bringing this legal action to recover the damages suffered as an excluded competitor foreclosed by the defendant's conduct from effective competition in the relevant market. The company noted that if it had been allowed to compete with defendants and their co-conspirators, it would have gained market share at defendants' expense while posing a competitive check on defendants' ability to charge exorbitant prices for brokerage services to consumers. By excluding Homey and other new entrants, defendants in a single stroke harmed competition, harmed consumers, and caused injury and damage to Homey. Like the antitrust lawsuits filed by consumers, Homey's suit also takes aim at NAR's rules, including the participation rule, which required listing brokers to make a blanket offer of compensation to buyer brokers in order to list a property on the MLS. A self-described technology-driven industry disruptor, Homey's business model involved charging home sellers a flat fee to list their property on the MLS. Now, they're not the only ones that have done that. There's other companies that have done the same thing. I mean, even I have a flat fee service that is right, that could be right for a lot of clients. Not everybody, but could be right for a lot of clients, depending on what it is and what services that they need from me. Okay, so this isn't really anything new. As part of their low-cost selling strategy, sellers using Homey would commonly make an offer of compensation to buyer brokers that was somewhat below the buyer agent compensation offered by sellers represented by traditional brokers, including the corporate defendants. Buyers using Homey would receive some or all of any BAC offered by the seller. The offer of buyer agent compensation a seller decided to make would be posted on the MLS alongside the listing, which is pretty normal standard operating procedure before Sitzer Burnett took effect. According to the complaint, buy-side agents made it clear to Homey that they did not like these lower offers of compensation, using the MLS comment field at Facebook to note that they weren't going to show Homey listings due to the lower offer of buyer broker compensation, which is known as steering. Now, back when I first got into the business back 21 years ago, I was a mortgage loan officer. And I overheard conversations from agents that were in my office and agents that I marketed to outside of my office that didn't like low commission offers. Matter of fact, they had a saying. They used to call it too low to show. So, and back then it was like anything under 2.5%, they essentially would not show or just refrain from showing. So, they didn't really think about things like, fiduciary duty, to see if the property was actually good for their client or the best property for their client. They were really more concerned with what commission they were getting out of it. Now, that's not everybody, and even today, I certainly do not care that there is a commission, what the commission is, just that there is one, or that there is some way of me being compensated, especially with the new rules. As long as that is worked out, I'm willing to work for my client and do the very best for my client. Unfortunately, though, there are a lot of agents back then and even now that don't look at it that way, unfortunately. The compensation is everything, and if there's not enough compensation being offered by a seller on a property, in my opinion, they will do a disservice to their buyer client and not show them the property. But anyway, let's go ahead and keep reading. Local NAR members in Utah use Facebook groups to coordinate boycotts. Wow, coordinate boycotts of Homey listings with low buyer broker commissions during the period that buyer broker compensation rule was in effect, sometimes marked with the hashtag boycott Homey. That complaint states the exclusionary campaign against Homey was also conducted through the local association of NAR in Utah that own control of WFRMLS, Local associations of NAR in Utah encourage agents to steer clear away from Homey, one of their own members. That would be interesting to see what evidence they have that show that NAR encouraged people to steer clear of Homey. In addition, the suit claims that Homey received text messages from NAR member brokers when the participation rule was in effect, claiming that the buyer broker would not show the Homey listing as the buyer broker compensation was only 1.5%. Looks like they have one of them here. I could always show it and then negotiate up the BBC in the contract, but I figured why go through the hassle when we have 3 other great listings paying 2.5 to 4% anyway. Please tell your sellers for me. One text cited in the complaint stated, by boycotting Homey listings and steering clients, Homey claims that the innovative entrants seeking to compete on price and other terms of service attractive to home sellers or home buyers have been stymied by traditional real estate brokers who acted in concert through the MLS to promulgate a web of rules and practices that created substantial barriers to competition. And yet there are barriers for anybody that's trying to come in that's trying to affect major change. Now, if you want to, lower commissions a little bit, if you want to do some subtle changes, you can survive in this market. But there are multiple reasons as to why in my opinion, why a lot of those companies don't work. Okay, and sometimes it has nothing to do with someone being anti-competitive. It's just sometimes the business model just doesn't work or just isn't attractive to agents. Anyway, let's go ahead and keep reading. The complaint states that while competition from innovative market entrants has been predicted for years, no firms have emerged due to the anti-competitive conduct of traditional brokerages acting through NAR. The anticipated wave of disruptive innovation and entry into the residential real estate brokerage market has not yet occurred because defendants conspired to prevent it, the lawsuit states. I do see how someone might be able to make that claim. Now, whether it actually happens or whether it happens on such a large scale, well, that has yet to be seen. Using the control of the MLS, defendants imposed rules nationwide that erected substantial barriers to entry for new competitors, thereby elevating the price of residential real estate brokerage services well above competitive levels. Although Homey has undergone several rounds of layoffs since its founding in 2015, as of April of this year, it is still offering brokerage, mortgage, and title services to consumers. However, it has moved its real estate agents from W-2 employees to 1099 contract workers. Homey is asking for damages and a permanent injunction against the defendants and is demanding a jury trial. Now, while we cannot comment on the specifics of the complaint, the claim that competition within the real estate industry has been stifled is simply unfounded, Chris Kelly, an executive vice president at Home Services of America, wrote in an email. The industry has undergone significant evolution over the past decade with dynamic changes in the competitive landscape. For example, of the top 10 brokerages by closed sides in 2013, only 3 remained in the top 10 in 2023. Notably, 7 of the top 10 brokerages in 2023 were not in that group just 10 years ago. There has been an ongoing and continued education of new models such as iBuying that have emerged over the past decade. I'm not sure that that's really a great example cited by Mr. Chris Kelly, but I guess it's an argument. In an email comment, a NAR spokesman said the trade group would respond to the allegation in court. NAR's goal is to promote local real estate marketplaces that provide fair and equal access to property information and promotes competition while empowering realtors to serve clients on their home buying and selling journeys, the spokesperson added. RE/MAX did not wish to comment, and none of the other defendants returned a request for comment. So once again, very interesting article. And then I also got an email from the notorious ROB. This is a email, and then sometimes I do subscribe and actually read the articles that he has. I will probably read this one, but he sent out this email, kind of a teaser email. It's called Another Bombshell Lawsuit Filed, Homey versus NAR. This one is different from all the others, and it's a real threat. I have the greatest community in real estate filled with the most informed and most knowledgeable people in the industry. One reader sent me the latest in a bombshell lawsuit just filed today. It is just starting to hit the news, and interwebs and the court filing system. The lawsuit is, or I assume will be named, Homey v. NAR. There is no link to reference, as I don't see one live, though if you have Pacer, maybe you can find one. Homey v. NAR is the next front in the antitrust lawsuit arena, and it is one that I don't think everyone is prepared for. I agree with him. This one is dangerous, precisely as Merle v. NAR lawsuit was dangerous, because the lawyers involved are not ambulance-chasing morons, and because the plaintiff is not a random home seller or home buyer, but an actual corporation with money. You never know when it comes to litigation, but this one is the real deal. And then you can subscribe and read the article. But this one sounds like the next lawsuit people are going to be talking about. Now, it'll probably be a few years before this gets to trial, if it gets to trial at all. There's lots of things that can happen. I'm certainly not an attorney, but there are certainly things that can happen. And we'll just have to wait and see if anything comes of this. But I agree with the notorious ROB. This one could be dangerous because while we've had competitors on the sell side, in other words, companies that are willing to list your property for a lot less, the buy side was pretty much the same in the past. And now we're starting to see, or at least it's alleged that we had a company, Homey Technologies, that was offering less than what was traditionally or normally offered, let's just say, to a buyer's agent, and they're claiming that they were harmed. Now, if this lawsuit goes the way of Sitzer Burnett, this could be way more, I don't know if you want to call it harmful or effective, or it's going to affect our industry much more than Sitzer Burnett ever could. So this is something that you guys want to keep an eye on. I'll go ahead and comment on it as more information comes in. Like I said, apparently this was just filed, so we're going to have to wait and see what happens. But for now, I know we're all dealing with the changes that have just come up with the Sitzer Burnett lawsuit, with the settlement, and we're all adjusting to that right now. And I couldn't imagine a year from now having to do this all over again. So we'll just have to wait and see. All right, guys, this has been the Real Estate Pro. We'll talk to you next time.